Hello, I'm Eleanor Wong, and I'm the Vice Dean for Student Life and Global Relations. On behalf of my fellow deans and everyone else here at NUS Law, welcome to our beautiful Bukit Timah campus. This is where more than 60 years ago, the Department of Law of the then University of Malaya began. And it was then the first and only law school in Singapore, and we are so proud to be part of that history and tradition. The Moot that you're also about to see is also part of that proud tradition. Not just because so many NUS students do well in domestic and international competitions, and not just because of the obvious populist connections between images of advocates standing up in court, making razor-sharp arguments, and the practice of law, but because I like to think that here at NUS Law, the practice of mooting encapsulates and embodies so many of our core values that concern the deep rigor with which we approach the study and analysis of law, the hard work that we put in to make sure that every argument we run is sound and is backed up to the hilt. And of course, the teamwork of working with other brilliant colleagues whom we support and collaborate with. So in a little while, I'm about to hand you over to our wonderful students of the Mooting and Debating Club to tell you a little bit about the case that they're going to demonstrate for you and the format of the Moot that they're going to show you. But I want you to think, as you look at what is a simulation of a court case, beyond that, to what law is about in real life. Many of our mooters have gone on to lives of deep service to others, to their clients, and to the country. They form our judges, they are our attorney general, they are our ministers, they are senior counsel in many firms, and they dedicate their lives to helping others to come to fair and just outcomes. This is something you won't see in the Moot because it is still just a simulation, but that you will see if you decide to join us at NUS Law and later on go on to a career in law. I hope you'll think about that deeply. And in the meantime, enjoy.
May it please the court, my name is Kevin Tang, and I appear for the appellant, Collectors Incorporated. I will be speaking for 8 minutes and respectfully reserve 2 minutes for rebuttals. Your Honour, the facts in the present case are straightforward. My client is the owner of an NFT of a beautiful artwork of a robot and asserts that it owns copyright in the artwork. The key problem is that this artwork was created not by a human, but an AI program. Therefore, the issue that this court must decide is whether AI-generated artworks are protected by copyright. According to the Copyright Act, this depends on whether we can find any human author of the artwork. My case is that the programmers of the AI should be considered authors because they satisfy the prevailing test for authorship. The prevailing test requires the programmers to have expressed creativity directed at the artwork. It is very important to appreciate what it means for one's creativity to be directed at the artwork rather than directed elsewhere. The case of Global Yellow Pages is a very good illustration of unrelated creativity. That case concerned a phone book compilation, and this court noted that creativity in gathering or verifying phone numbers did not count because that creativity had nothing to do with the way those phone numbers were ultimately compiled and expressed. Turning to our facts, I concede that the creativity of the programmers in programming the AI was unrelated and does not make them authors. However, it is the creativity of the programmers in teaching the AI that I argue is directed at the final artwork and therefore makes them authors. It is important to appreciate exactly how the programmers taught the AI. During this process, the programmers first gave the AI access to a massive database of images on the internet and taught it how to identify which of these pictures were likely to be successful as NFT artworks. The programmers did this through a method known as reinforcement learning. What this means is that in the very beginning, the AI would generate an image almost at random, and the programmers would give it feedback, such as by saying, "This image looks terrible." Then the AI will go back and select another image, and the programmers will react by saying something like, "This looks great." And so through this lengthy reiterative process of reinforcement, the AI would eventually learn which pictures the programmers thought were likely to be successful NFT artworks. So, how exactly was the creativity of the programmers directed at the final artwork? Well, the programmers were effectively telling the AI that they liked colorful images or pictures with bordered lines by approving pictures with those features and rejecting pictures with unwanted features. Thus, the creativity of the programmers was reflected in the underlying artwork, which was generated according to the stylistic preferences of the programmers. This is clearly very different from the case of Global Yellow Pages, where the creativity in gathering and verifying phone numbers had nothing at all to do with the way the final phone book compilation was expressed.
Sorry, counsel, but isn't it the case that the programmers did not even know what the final image would look like? So how can we say that the programmers creatively contributed to the robot image when they did not even know that the image would be of a robot?
Well, Your Honor, it is actually possible to creatively contribute to something without actually knowing how the image will ultimately turn out. This is analogous involving a situation with two artists, one of whom is blind. The blind artist can't see the artwork, but he can creatively contribute by saying things like, draw something colorful like the rainbow, draw something with bordered lines. And it is clear that the blind artist is creatively contributing, even though he cannot see what the final artwork will look like. This is analogous to the present case.
Sure, but isn't it the case that the AI has the ability to add its own creative elements in addition to what the programmers taught it?
That's a good point, Your Honor. However, our law does not require the author to have been the sole contributor, the sole creative contributor. It suffices for the programmers to have been one of the contributors to the creativity in the final artwork. Of course, usually when this happens, all people involved who have creatively contributed would become the copyright holder. However, in the present case, given that the AI does not have legal personality and cannot hold copyright, all the copyright will vest among the programmers and not in the AI itself.
Well, counsel, I certainly see the force in your argument that, AI-generated images are based on the creative expressions of the programmers itself. But by that line of logic is, for instance, a school teacher who has taught a student how to draw considered the co-author of that student's artwork?
Your Honor, that's a very interesting question. And I don't think thus far we have seen a case where a teacher has actually come to the court and claimed copyright in their students' artworks. However, I suspect that if that case were to come forward, it wouldn't be a situation where the teacher would get any copyright because of the transactional nature of the student-teacher relationship. In that relationship, a teacher gets paid to teach the student how to draw. And that is different because in that situation, both the teacher and student therefore do not expect the teacher to get any copyright works, even though the artwork that is produced by the student does reflect some of the creativity of the teacher. In other words, teachers and students can be seen as independent entities who are not acting together. This is different from the present case, where the programmers and the AI can be seen as working on the same team, and therefore the law has no problem with giving copyright to both of them if it were possible.
Sure, counsel, I think we must acknowledge that AIs are a relatively recent innovation. Can we really say that, the drafters of the Copyright Act intended for programmers of AI to be copyright holders?
Your Honor is correct to note that the issue of copyright in AI-generated artworks is a novel one, which the drafters of the Copyright Act could not have foreseen. However, recognizing programmers as copyright holders would promote the objectives of the Copyright Act. This is because copyright is justified in Singapore on partly utilitarian grounds. If we refuse to recognize programmers as authors, this will cause severe economic and social harms. Programmers would have much less incentive to develop AI programs that can generate artworks, because these artworks would have no copyright and therefore very little economic value. Furthermore, there would also be knock-on effects on society, who would have less artworks to enjoy. This is especially important given Parliament's aim to transform Singapore into a smart nation by developing our AI and technology sectors, as Minister Edwin Tong noted in the second reading of the Copyright Bill last year.
Sure, Council, but well, even if we disincentivize programmers from creating AIs to produce, artworks, who is to say that they might not produce AI in other contexts? So is the alternative actually any worse here?
Well, Your Honor, it is certainly possible that these programmers would simply go and do something equally productive, but it isn't very probable. It is important to realize that AIs that can generate artworks attract a very unique group of individuals who represent the intersection of those who are interested in programming and artworks. And therefore, these individuals would not be making full use of their skill sets if they were, for example, to develop AIs related to non-artistic things or to do artistic tasks unrelated to AIs. Therefore, there is utilitarian benefit in my case, where we do incentivize people to create AI programs which generate artworks. Therefore, Your Honours, the creativity of the programmers was directed at the final artwork, and the requirement of authorship is fulfilled. For this reason, copyright subsists in the underlying artwork. If I may be of no further assistance to this court, this concludes my submissions. Thank you.
May it please the Court, my name is Jared Chen and I appear on behalf of the respondent, Opportunity Venture. I'll be speaking for 8 minutes and I'll reserve 2 minutes for rebuttal. Your Honour, while the appellant may be the owner of the AI-generated NFT, it does not follow that the appellant may exert copyright protection. Crucially, copyright protection is only accorded where there is human authorship. The issue before this court is therefore whether there are any identifiable human authors attributable to this AI NFT artwork. On this note, we argue that the programmers are not authors, for they fail to demonstrate authorship skills. The test for authorship requires putative authors to have expressed creativity and directed at the artwork. The operative terms here are 1, expressed creativity, and 2, directed at. We will address these terms in turn. Firstly, the requirement of expressed creativity comports with the principle that only expressions of an idea and not the ideas themselves can be accorded copyright protection. In other words, contributions of mere ideas do not amount to authorship. The case of Donahue and Allied newspaper is illustrative of this ideas and expression dichotomy. This case concerned articles published in the newspaper. While the plaintiff was originator of the ideas of the article, the court held that the newspaper writer was in fact the sole author who gave the expression in terms of language and the literary style to these ideas and therefore is the sole author. Your Honour, I now turn to the present facts, and we argue that the contributions of the programmers to the NFT artwork fall within the ambit of ideas. As explained by the appellant, the AI operates via a machine learning method known as reinforcement learning. This involves a reiterative process of feedback from the programmers, where the AI generates an artwork which is then vetted by these programmers who will give a feedback in terms of whether this is desirable or not. And in receiving this feedback, the AI then produces the final output, which is the present NFT artwork. Therefore, it is the AI which is the party which gives rise to this final expression, not the programmers. Thus, the programmers are not the authors of this NFT artwork.
Counsel, would your analysis change if the programmers had in fact set coded boundaries on the output of the AI? Would this then amount to contributing to the material expression of the NFT in artwork?
Your Honour, in our view, this will in large depend on how wide or narrow these boundaries would be. In our view, if the programmers give specific instruction, the narrowest possible boundary that is set, to choose a specific color or to pick a certain image that would amount to authorship. Whereas if there is room within this boundary for the AI to then decide what is the final output, then it falls within the ambit of a mere idea, and it is not sufficient for the programmers to then be considered the authors of the NFT artwork.
Well, counsel, in preparing your bundle of authorities, you have used word and printing software to materialize the final expression of your ideas. By your line of logic, would you be considered the author of your bundle of authorities?
That's a fantastic question, and in our view, I would definitely be the author, because in making this bundle of authorities, I give specific instructions as to how the word is supposed to arrange the authorities. For example, I would say, or rather I would express to the word software that I would want the Copyright Act to be the first authority on my list and Asia Pacific Publishing to be second on my list. And in doing so, I specifically give instructions to these word softwares, and because of that, I am the author of the bundle of authority. Alternatively, Your Honor, this example you raised may also, in my view, be justified on grounds of control, which I will now address. For one to be recognized as an author, the putative author needs to have demonstrated that he is part of the actual creation of work as compared to merely facilitating or just doing the preparation for the actual work to be done. As explained by the court in Telstra, in the context of computer-generated works, this requirement turns on the crucial question of control over the final expression of the work. In the present case, we argue that the programmers have no control over the NFT artwork. They merely give feedback to the AI, who is then free to make the decision as to how the final expression takes form. This can be contrasted with the case of Global Yellow Pages, where the authors, the marketing department of the company, dictated the final selection of the yellow pages by determining the extraction criteria for each of these directories.
Counsel, if we adopt your position, wouldn't programmers of AI be disincentivized from creating such AI in the first place? And this is because they would not have control over the final expression of the AI program and thus will not be granted copyright protection.
Your Honor, I would not venture as far as to conclude that the programmers will be disincentivized from creating these AIs. In our view, the incentive for the creation of AI is provided for under the Patents Act. If the programmers can demonstrate that their creation satisfies the requirement of novelty, innovative step, as well as industrial replication, then they qualify for a patent and they are then allowed to exploit this patent for commercial gains.
Certainly, counsel, I get that under your position, programmers of AI may be granted an incentive under the Patents Act. But we must acknowledge that they are not granted the additional incentive under the Copyright Act, and especially where they use non-AI software such as Photoshop to create that artwork. So, in effect, does your position disincentivize higher levels of automation?
Your Honor, thanks for the opportunity to clarify again. Just two quick responses to that. Firstly, it is doubtful whether the user of non-AI softwares like Photoshop would be awarded the incentive under the Patents Act, specifically because they do not satisfy the requirement of an innovative step. And this conclusion in our view, comports with our view that the incentive awarded needs to correspond with what has been created. The artist or the user of Photoshop creates an artwork, and that is subjected to protection provided for under the Copyright Act. Whereas these programmers, they create the AI, and that is provided for under the Patents Act. Therefore, in our view, the programmers should not be given an added incentive that is under the Copyright Act. Furthermore, while it may be desirable to confer an additional incentive to these programmers, it's also important to recognize that copyright laws are governed by statute. And as it stands, our copyright regime does not allow for AI to be authors, nor does it allow programmers of these AIs to be recognized as authors. Accordingly, in our view, it is up to the legislature to decide whether the existing provisions need to be amended, such as to confer an additional incentive to these programmers of AI. In conclusion, Your Honor, for the reasons of an idea and not an expression, as well as the degree of control or the lack of degree of control that the programmers exercise over the final NFT artwork, we conclude that the programmers are not the authors, and there is no identifiable human attributable to the creation of the NFT artwork. Thank you, Your Honor.
Your Honor, just two quick points to make. First, my opponent points out that our law only protects expressions of ideas and not the ideas themselves. This is correct, but it's important to note that the ideas here refers to the content of the artwork, and that is what our law does not protect. In this case, the content or the idea is the idea of a robot. My client is not applying for copyright protection over the idea of a robot. What we are applying for copyright protection for is over the way this robot was expressed. Focusing now on expressions, my opponent mistakenly assumed that because our law only protects expressions, that means the authors must have personally expressed the artwork. This is wrong. The key question is whether the authors, in this case the programmers, have contributed to the expression even if they did not personally express it. For example, a blind artist without limbs who draws by telling his helper exactly what to do is still an author because he has contributed to the expression of the artwork, notwithstanding that he did not personally express it. My opponent can semantically label the verbal contribution of the blind and limbless artists or the programmers as mere ideas. But his use of the word ideas here is different from the meaning of ideas in the idea-expression dichotomy. In that situation, the word ideas refers to the content of the artwork, which is only the robot here. Therefore, the programmer's contributions by telling the AI that they like colorful images or that they like bolded lines is more than an idea. It's a contribution to the expression of the final artworks. Secondly and finally, as to my opponent's point that the programmers will still obtain patent in their AI, this is correct, but it misses the point. Patent law can only protect the AI software itself, but it does not protect the artworks generated by such software, thus rendering the programming of AIs still of little economic value because the ultimate artworks that those AIs are producing is not protected by either copyrights or patents. This therefore disincentivizes programmers from undertaking such projects, causing economic harms to Singapore. For these reasons, we urge this court to find that AI-generated artworks should be protected by copyright. If I may be of no further assistance to this court, this concludes my rebuttals. Thank you.
Your Honor, just 2 points for my rebuttals. First, the appellant contends that the law does not require the authors to personally express the artwork. Your Honor, I do not disagree with this statement, but in our view, his arguments fail to distinguish the difference between an idea on one hand and an expression on the other. An idea refers, in our view, to guidelines that are given by the artist, whereas an expression is the way an output should be executed. In the example of the blind man and his assistant raised by the appellant, the blind artist is no doubt the author because he is the party who gives specific instructions to his assistant as to how the drawing should be materialized. The situation will be different if the blind man instead gives mere guidelines to his assistant as to how this drawing should materialize. For example, the color blue is popular. That would be insufficient to amount to such an express intention or rather giving these specific instructions. On the present facts, the programmer's contributions are akin to the latter. They do not dictate the execution of the artwork and should not be considered authors. Secondly, the appellant claims that without copyright protection for the artworks, the creation of AIs would be of no or little economic value. Your Honor, this is quite plainly not true in our view. The sale of NFT artworks confers ownership of the artwork to the buyer, but not the ownership of the copyright that underlies the artwork. Even without this copyright that is underlying the artwork, these NFT artworks are fetching significant prices. For example, an NFT artwork called The Merge was recently sold for a price of 91 million US dollars. So unless the appellant claims that the potential to earn 91 million US dollars from one piece of artwork that is created by these AIs is insufficient incentive to warrant creation of such AIs, I will conclude my submissions, Your Honor. Thank you.